Please be seated.
Good morning, everyone. Once again, we're delighted to be sitting here in Pasadena. Before we begin, Judge Sanchez and I would like to welcome and thank Judge Fitzwater, who's sitting with us from the Northern District of Texas. Welcome and thank you, Judge Fitzwater. The cases will be called in the order listed on the docket. The first two cases, United States versus Sanford and Murch versus United States, have been submitted on the briefs. The first case on calendar for argument is Doe versus WebGroup. Counsel for appellant, please approach and proceed.
Good morning, Your Honors.
Good morning.
Mr. Banks. May it please the court. I would like to reserve 3 minutes for rebuttal. And then also, I'd like to start by just highlighting.
Counsel, please be reminded that the time shown on the clock is your total time remaining.
Thank you, Your Honor. Thank you for explaining that, Your Honor. I'd like to begin by highlighting some of the points that we made in the briefing in this case. Initially, I'd like to begin with the third element of the Section 230 affirmative defense that the defendants have brought in this case. That's the content provider and material contribution element of proving 230 immunity defense. This is an affirmative defense. The burden is on the defendants on this case, and the only way that this case can be dismissed at the pleading stage is if the plaintiff has pled herself out of court, meaning that she has pled all of the elements of an impenetrable defense that can't be overcome in any way. I respectfully submit that whether the defendants are content creators here and whether they materially contributed to the illegality of CSAM on their websites is at a bare minimum a factual dispute that can't be resolved on a motion to dismiss.
Counsel, at any point did the plaintiff plead that the defendant was a publisher?
I don't believe that we did affirmatively plead that they're a publisher. As a matter of fact, we dispute whether they're a publisher. However, to be very direct about it, I'll discuss that. With regard to the publishing function, we believe that this case is different than Reddit and even the Twitter case from the standpoint of the actual duty that was being undertaken here by the defendants. They were doing more here than just allowing people to put CSAM on their websites and then profiting from revenue that they generally collected from their website. Those were the allegations in the Reddit case and in the Twitter case. However, here, while it's true that we make similar allegations, we also specifically allege that there was a revenue sharing relationship between these defendants and the trafficker of the plaintiff in this case, and indeed all of the content.
What was the nature of the revenue sharing relationship?
The nature of the relationship is the way
revenue sharing relationship. Yeah. What was the nature of that?
When you become a content provider on XNXX or X videos, based on the number of views that videos you provide, number of hits it gets, the number it collects, right, you can possibly get to share in revenue.
But how's that different from Twitter or any of the other Reddit or any of the other content providers that we have discussed in our precedent?
My understanding, Your Honor, is that in Twitter and Reddit, someone who posts something on those sites does not share revenue from the website. The website does not give revenue. So if I post on Twitter something about the Los Angeles Dodgers and it gets a whole bunch of hits, my understanding is, and based on the cases, and I didn't see anything in the precedent in the opinions to suggest that Twitter does not send me a check or give me some kind of financial remuneration potentially based on the number of hits my Los Angeles Dodgers tweet got.
So are you saying in this case the defendant directly sent money to the people who were manufacturing the websites? Is that your allegation?
Your Honor, at this point, the allegation is that the content provider who provided the CSAM of the plaintiff was one of these content partners and was eligible to receive revenue.
Where is that in your complaint?
Excuse me?
Where are the details of that in your complaint?
In paragraph 196, Your Honor.
So a moment ago, counsel, you said that I wanted to just clarify one thing. Is it your allegation that the person who uploaded Doe's video was one of the sex traffickers who trafficked her?
Yes.
Where is that in your complaint? Because it's not altogether clear
Well,
what you meant by that.
Your Honor, I don't know if it's specifically stated the way you asked, but it's repeatedly said here that the person who trafficked her was a content provider.
Well, I mean, the reason why I ask is because there's a portion of your complaint that seems to rely on the notion that someone who uploads a video is causing the victim to perform a commercial sex act. And is your theory based on that?
No, our theory is based on the fact that this plaintiff was raped when she was 14 years old. Her trafficker raped her, took videos of that, and we know that that person is the one who uploaded those 4 videos to the defendant's websites.
So that person who was involved in that trafficking act was the person who uploaded the videos?
Yes, sir.
And are there any allegations that WebGroup knew that the person who uploaded the videos was someone who trafficked Doe?
Well, the allegation may possibly, I don't know if there's an allegation that at the time it first was uploaded and the time that it first appeared on the website, the defendants knew. However, at some point, the plaintiff herself notified the defendants about all of the circumstances of these 4 videos and asked them to remove it from their sites. So at least at that moment, they fully understood the circumstances, and they allowed those 4 videos to stay on the website for over 3 more years.
I mean, what I think I have a bit of a problem with the TVPRA claim is I understand the revenue sharing seems to be distinct from the other cases, as you mentioned, but I think the allegations still fall short in the knowingly participated in a sex trafficking venture, in the sense of, did WebGroup know that the uploaded videos were by the person who trafficked and were actually trafficking videos themselves?
Well,
so what do you think? What are the best allegations in the complaint to point to get into those details?
Well, Your Honor, I'd point out not only the revenue sharing relationship allegations in paragraphs 125 and 196, I'd also point out the fact, the allegations that the defendants affirmatively knew about the circumstances of the plaintiff's situation that we just discussed when she notified them about her trafficking. I'd also point out the fact that
what did she tell them about the trafficking situation?
She notified them that these were CSAM videos and asked them to remove them from the site.
But that's not the same thing as saying that these are videos in which I was trafficked and the uploader was the one who trafficked me.
Well, I believe, and I can't give you a citation on this, Your Honor, but I believe that when a minor is subject to trafficking, is subject to abuse in this way, it falls within the definition of trafficking. So, and there's also allegations, I believe it's in paragraph 123 of the second amended complaint, that these defendants, they review all of the videos that they allow to go up on the site.
Because now I think you're talking about things that were covered in Twitter and Reddit, right? I mean, if I understand your argument, it's that if a minor is reporting to WebGroup that this is, illicit material, it's child pornography, and they don't take it down, then that would mean that they are actively participating in a sex trafficking venture. And that argument was rejected in both Reddit and Twitter. And so that's why I'm looking for something more specific here as to whether there was something that would give WebGroup knowledge that these particular videos were the ones that she was trafficked in,
Well,
as opposed to a general umbrella of this is child pornography that's illicit.
I understand, Your Honor, and respectfully, I believe that we should be given the opportunity to conduct discovery into all of these things and how they work, because these websites are different than the Twitter and the other ones. Here we know, and the allegations are, that these defendants actually promote and profit from CSAM, that they knowingly do that. Now, whether not necessarily that they knowingly know about the plaintiff, admittedly, Your Honor, but they know about the CSAM on their website. They create these tags, search terms, thumbnails, various other things that we discussed under the material contribution element of Section 230 to suggest that they actively know about these things, they profit from these things. I would respectfully submit that reasonable inferences can be drawn that should allow us to conduct discovery as to exactly how those operate. And I'd also suggest that those things like tags that are created, like toddler,
Can I ask,
things like that.
are the tags, there was a little bit of confusion for me, are the tags being created by WebGroup or by the users? Because I thought the allegations were that most tags and keywords are user generated.
That is not the allegation, Your Honor. There are 13 allegations in the complaint. 13 times it's specifically alleged that it is the defendants that create and generate the CSAM tags and search words. There was confusion in the district court when Judge Garnett dealt with the first amended complaint and dismissed on other grounds in ruling on the first amended complaint. We're here on the second amended complaint about whether or not the defendants or the users created those tags. However, at no time did the plaintiff ever say that it was the users that generated those tags. There was some suggestion that at an earlier argument, counsel for plaintiff may have said that. However, respectfully, if you look at the transcript from that hearing in the district court, there is no such concession. In addition, there are 13 specific allegations, and the paragraphs are noted in both the opening brief and the reply brief of the appellant here that specifically say it's the defendants that create those tags.
And what is it? And why do you think that these tools are not neutral? Is it because the tags have certain names that should have a certain connotation for that type of website, or is there something more?
It is because these tags, and once again, this is why, respectfully, I believe that we should be entitled the opportunity to conduct discovery and try to prove our case. But those tags are associated with CSAM. That's the allegation in the complaint. And I would submit that when someone identifies a piece of CSAM with the words like toddler or seventh grader or hairless, that those people are, that it's very clear in the context. And remember, this is a pornography website. This isn't Twitter. This isn't even a Google search or a general search engine. These are terms that are created and suggested by the defendants themselves in the context of a pornography site. We also know that they actually do data mining where they review how many hits these different tags that get, and they associate them with these videos. So it's our belief that in the context of this case, it's like in roommates. In roommates, the criteria in roommates, well, roommates teaches us that context matters. And it matters because in roommates, sex, sexual orientation, family status were problematic in the housing context. This court in roommates said they may not be problematic on another website, like a dating website, but they are problematic here. I would submit to you that terms like I went through, toddler, terms like that, in the context of a pornography site are hardly neutral. They actually go to the very illegality of CSAM in this case.
Would you, because you don't have much time left, would you address your view on the FOSTA exception and whether that makes a difference in how we treat the claims?
I would submit, Your Honor, and this goes back to some of my discussion with Judge Sanchez about the TVPRA claim. I would submit, and we've briefed this, we believe that the FOSTA exception does apply. However, even if this court were to decide that the FOSTA exception does not apply in this case, if you find that the plaintiff has pled enough to suggest that the defendants have materially contributed to the illegality of the CCM on their websites, then the case cannot be dismissed at the pleading stage.
Thank you.
All
Thank
right,
you.
counsel, you have 35 seconds remaining.
Thank you.
May I proceed, Your Honor? Good morning. I'll start with the Barnes prong 2.
Did you introduce yourself?
My name is Adam Banks. I'm here for defendants WebGroup. And good morning. I'll start with the Barnes prong 2 just because, Judge Wallinson, you asked about whether the plaintiff pleads that they're a publisher. And I think it's clear that under this court's precedents, in particular Twitter, that they do. As this court has said many times, any activity that amounts to deciding whether to exclude material that's on a website that's posted by a third party is perforce immune. And the allegations here that we receive revenue based on advertising relating to CSAM invokes that liability just as it did in Twitter. The only way to avoid liability for that under plaintiff's own theory is to take off the illicit material. That's quintessentially publishing activity, as the court said in Twitter. And I think the complaint itself proves it up. If you look at both the allegations that are challenged in terms of our failure to monitor and remove CSAM from the website and the relief that it requests, which is to remove that material, it's very clear that triggers the publishing duty.
Counsel, what's your response to opposing counsel's reference to paragraphs 196 and 197, where an allegation is made that there's a revenue sharing relationship, and his representation that there were direct payments?
Sure. So, if Your Honor, I think the better place to look for this in the complaint is paragraph 123.
But before we go there, could you address those allegations in 196 and 197?
Yeah, so the allegations in 196 and 197, Your Honor, the way that the platform works, and this is where I was trying to direct Your Honor earlier, is that if you post a certain number of videos of a certain length, you become a channel partner and you have the opportunity to monetize that relationship. That's what's alleged in the complaint. And what the complaint says is that gives you opportunities to generate advertising revenue and so forth.
But it's advertising revenue and not direct payment for content.
Correct. The only allegation as to direct payment to content, and again, Your Honor, this is very conclusory. It's in paragraph 216 of the complaint. It just says that we're paid, that some content providers, not just CSAM providers, but all content providers who are channel partners are paid in part for the content that they promote. But there's no detailed allegations about what that means. And the reason it's important—
216 is a very long paragraph. So which section?
C, I believe, Your Honor.
C and D?
I think it's C as in cat.
Yes.
Yes.
Okay.
And the reason why it doesn't matter for this particular claim is that, as the court has made clear in many cases, it's neutral as to the content. So the content partners collect revenue regardless of what they are posting. So both CSAM and non-CSAM. It's not the case where WebGroup knows or seeks out CSAM providers in particular and pays them for providing CSAM. So it's just like the other many types of allegations that this court has found, Reddit, Twitter, etc., where it's content neutral insofar as it's the same tools that apply to challenge activity and not.
I mean, but we haven't seen allegations that in the other cases that ad revenue was shared with content uploaders, have we?
Not exactly those allegations, but again, I don't think it makes a difference insofar as it's neutral as to the content that's being uploaded. And I think the other way to think about it, if you look at the Google case, the Google versus—
Well, I mean, what if it's not neutral in the sense that, like, that there's knowledge? Let's say there's a channel that was dedicated to CSAM.
Yeah.
And that channel provider is being paid money, even in the mechanism of paying it to other people, but it's illicit. Doesn't that get us closer to a TVPRA or some type of claim that's different than all these other cases?
So I think there's two responses to that, Your Honor. The first one, again, if we're in the 230 land, you're looking at the material contribution test. The test is, are they materially contributing to what makes that material illegal? And they're not. The videos would be CSAM regardless of any advertising, regardless of any revenue associated with it or not. There's no contribution by the website to making that illegal. That's the Kinsey case and other cases that set forth that rule. And I think the Kinsey case in particular had to do with defamation. But the rule, the way it was articulated was, does the tool or the activity enhance the illegality of what's going on? And the ad revenue and revenue sharing and all those tools don't do that. So that's the first answer. The second answer, I think, Your Honor, is, and again, I'll direct you to the Google case about the support of terrorism. And I think that case draws a very instructive line. What it says is the revenue sharing allegations, they were actionable because it mattered who they were sharing revenue with, not the content of the posts that were generating the revenue. So in that case, the sharing money with terrorists was illegal, but it didn't have to do with the content of what was being shared. So if the terrorists had posted videos of puppies, for example, it still would have violated the statute and not been immune. It didn't depend on the content. In that case, the allegations that did depend on the content were immune. So to the extent that they were alleging that watching a video of terrorist training encouraged them to then go out and commit those attacks, that was immune because it depended on the content of what was being posted. And here, I think it's very clear that their allegations didn't depend entirely on the content of what was posted. These revenue sharing allegations are only problematic in the plaintiff's view because they're attached to CSAM videos, not because they're attached to other videos. And again, if you look at the relief that the complaint is asking for, it's not asking for revenue sharing agreements to stop. It's not asking for the tags to come down. It's not asking for the keywords to stop. It's asking for the videos to come down. And that's squarely what 230 is about whether you have to moderate and remove the content.
What is your sense of what the allegations say about the uploaders and WebGroup's knowledge of whether WebGroup knew that these videos were connected to sex trafficking?
Yeah, there's no allegation that WebGroup knew that they were connected to sex trafficking. The allegation that my friend points to with respect to notification of the videos of plaintiff, it's at paragraph 199 of the complaint, and it says only there that notified us of abuse videos. Doesn't specify any more about what was in those videos. And in fact, the first amended complaint did go into more detail about using the website's notification pages and providing information. That was deleted from the second amended complaint. It's no longer there. So the only allegation about our knowledge with respect to the CSAM of plaintiff is that when we received the attorney letter about it, we took it down, and that's in paragraph 200 of the complaint. There's no other allegation that we knew. Sorry, Your Honor.
Oh, I thought opposing counsel said that the victim herself contacted your client and the material remained up for 3 years after that. What's your response to that?
That's not alleged in the complaint, Your Honor. If you look at paragraph 199, again, like I pointed, Your Honors, to, that's the only place where plaintiff alleges she contacted us about the videos, and it says about abuse videos and nothing more. And the following paragraph says when she told us the details about the abuse videos in an attorney letter, which is also in the record, we took it down. And I think that's important because it goes to both the knowledge element of the CSAM claims itself, but also as it relates to Judge Sanchez, your questions about knowingly participating in any sex trafficking venture. There's no allegation that we knew the videos of her involved sex trafficking at all. And again, when we were alerted about the nature of the videos, we took them down as alleged in paragraph 200 of the complaint.
But in 199, she said she reached out multiple times over the years requesting her abuse videos be removed, and she never received a response.
That's correct, Your Honor. But that's all that she alleges. She doesn't say I was underage in the videos, that these were videos of me being sex trafficked, that these were videos of me being underage involved in activities. She doesn't say how or when. And the reason I'm pointing that out, Your Honor, is because in a prior version of the complaint, she had more detailed allegations about that, and she removed those allegations in the second amended complaint.
So your position is once the demand letter came with details, it was taken down?
That's right. That's right, Your Honor. And this case was before this court previously on a jurisdictional issue there, and this issue came up again there. I'll just say the court noted for the record that we'd offered, again, this is a motion to dismiss, so I'm not asking to make factual findings, but that we had no notice of those prior attempts until we got the attorney letter, and that was taken down.
Would this case be different if WebGroup knew that the uploader had been a person who sex trafficked Doe?
It would be.
Are we then in the TVPRA land and in the FOSTA exception in that case?
I don't think we would, Your Honor. We'd be closer, but we wouldn't, because again, the allegation in the TVPRA context or FOSTA is that we knowingly participated in a knowing sex trafficking venture.
Right.
And
I mean, you
and
could
don't
imagine,
think-
let's
yeah.
suppose you have sex traffickers who are producing the videos, and WebGroup's component of it is those videos get uploaded and they share ad revenues with the sex traffickers, and everyone knows about this. That would seem to me to be sufficient to state a claim at that point.
Yeah, that'd be closer. It'd be closer to us saying, "Here's some money, go make a sex trafficking video." That's not alleged in this complaint in any form. We're several steps away from that type of allegation.
We may not need to get to this, but I'm not sure I agree with the district court's resolution of the extraterritoriality issue.
Sure.
It seems to me that this case is a domestic application of the TVPRA. That you have a domestic victim who was sex trafficked in the United States and suffered injuries here. The fact that there's a foreign defendant that might have been involved in it doesn't make it extraterritorial. I know your answer is, well, there's no allegations about what defendants did, but if we're reaching that issue, then we've already, thought that there's enough involvement by the foreign defendant to be held in court and to be involved in it. Isn't this a domestic application in the end?
So here's the way that I've been thinking about this, Your Honor, is if you look at the specific claim that she's asserting against us, and at least with respect to the TVPRA claim, it's for benefiting from sex trafficking. And the Reddit case in at least two places, and again, I know that wasn't extraterritoriality context, but it says in a claim where it's a beneficiary liability theory, like it is here, the gravamen of that claim is what the defendants did and how the defendants benefited. And if you focus on that aspect of the claim, which is sort of what the cases, the Nabisco case and others say that you should do in a extraterritoriality kind of analysis, both of those observations point to the defendant's activity insofar as its benefit and its participation as being the gravamen of the claim and what the focus is on. And as it relates to this complaint, the allegations of our benefit and our activity are abroad and not in the U.S. And so in that respect, the specific claim that she's asserting is not a domestic application in that regard. So that's consistent again with the sort of the way the Rotha court handled some of this.
But Rotha, Thailand, moved to Cambodia, people are being trafficked for labor violations there. It seems pretty different to me then. I mean, if we go back to the hypothetical that I posed, if WebGroup is putting money into the pockets of sex traffickers that happen to be sex trafficking in the United States, I have a hard time seeing why the TVPRA would not apply in that instance, just because there happens to be a foreign defendant involved as well.
But yeah, and I agree with you, Your Honor. It's not just a foreign defendant; it'd be the foreign activity of engaging in the venture in the United States by sponsoring it through ad revenue knowingly and so forth. That's not alleged here. There's no allegation that before these videos were created, after their videos were created, there was some knowledge and participation on the part of defendants in that sex trafficking act. And again, that's what the cases had said, Twitter, Reddit, and so forth. It's the defendant's own conduct and the defendant's own actions that have to actually be involved in the sex trafficking in order to trigger the exception or to.
So I guess my last question is why your friend on the other side said, well, why do we stop at the pleadings? Why not let them prove their case? If there are disputes about to what extent WebGroup is involved in these things, why not let it get past the motion to dismiss stage?
Right. So two responses. Number one, again, Section 230, it is a affirmative defense, but it's also an immunity defense, and that has significance in terms of burdens on defendants for having to even defend cases like this. And the second is, I don't think there's anything materially different from this case than this court's prior precedents that would require getting into discovery in terms of any of the disputes that matter, right? So again, there's a dispute over who creates the tags and so forth. Again, I don't think it matters for the legal analysis who creates the tags. The tags don't contribute to the illegality of the content. The content would be illegal or not based on what's in the videos, not how they're tagged or categorized or keywords and so forth. And there's a litany of cases in this court talking about how making searches easier for people to find what they're looking for isn't content in and of itself. It's a neutral tool allowing users to find what they want. Doesn't constitute contribution by a defendant into creating that content. And so the various disputes that are being raised today, I don't think aren't factual disputes that go to the legal analysis of the claim and can be resolved on a motion to dismiss, as courts typically do in Section 230 cases. Thank you, Your Honor.
All right, thank you, counsel. Let's have a minute for rebuttal.
Thank you, I'd like to point out three things quickly. Then, Judge Rawlinson, in paragraph 196, it's alleged that the plaintiff's videos were removed from the websites in the fall of 2020. And then in 199, it's alleged she notified them in 2017. That's how I get the 3+ years.
I hear you.
Also, I'd like to say that there are three elements for 230 immunity. So even if this court were to find or conclude that these websites were publishers in this situation, if they materially contributed to the illegality of it, then the immunity would not apply. And then the final simple point I would make, beyond the TVPRA, there are other claims in this case. Specifically, there's child pornography claims that haven't even been addressed in oral argument today, although they are in the briefing. And there's also a claim under the California Privacy Act. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. The case just argued is submitted for decision by the court.